out of order.
Strada. Okay. Hold it clear.
Jocelyn.
Morning.
Good morning, everyone. Ladies and gentlemen, welcome, and thank you for being here today. Please turn off any cellular telephones to avoid interrupting these proceedings. The time is now 9:07, and we will call this meeting to order. Before we begin, I just want to provide you with an opening statement of how we will conduct these proceedings. There are no weapons of any kind permitted in these chambers or anywhere within these facilities. In all issues that may come before the special master, we ask that everyone show mutual respect for one another by listening quietly to each person speaking, and that everyone refrain from clapping, heckling, or verbal outbursts in favor or in opposition to a speaker. My name is Andre McKinney, and I will serve as your special master for today. These are hearings conducted by a special master for the purpose of which is to give any alleged violators the opportunity to contest the decision of the code enforcement officer, which resulted in the issuance of a civil violation notice. These hearings are conducted in a quasi-judicial manner, and I am the special master assigned to hear today's cases. My responsibility is to act much like a judge in a court, and that is to hear cases presented by the code enforcement officers and to hear contradictory arguments presented by the alleged violators. These hearings are open to the public. It is required that all persons who testify as to the facts of the case be placed under oath, including the code enforcement officer. These hearings will not be conducted in accordance with the formal rules relating to evidence and witness. Any relevant evidence will be admitted if I find it to be competent and reliable, regardless of the existence of any common law or statutory rule to the contrary. All documentary evidence must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or code enforcement officer submits a copy for the hearing file. Each party shall have the right to call and examine witnesses, to introduce exhibits, and to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in the direct examination, to impeach any witness regardless of which party first called him or her to testify, and to rebut the evidence against him or her. It is my responsibility to make findings of fact based on the evidence of record. The fact-finding determinations of a special master are limited to whether the alleged violation occurred, and if so, whether the person named in the civil violation notice can be held responsible for that violation. I may also modify the decision of the code enforcement officer as to the time for correction contained in the civil violation notice, even though said time is rebuttably presumed to have been reasonable. I have the authority to assess and to order the payment of civil penalties, to issue orders having the force of law, to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code enforcement officer's decision, I must find that there is substantial competent evidence that the named violator was responsible for a violation of the relevant section of the code as charged. If I affirm the decision of the code inspector, my order will specify the amount of civil penalty, the administrative cost of the hearing, not less than $100 if assessed, and the date by which the violation must be corrected to prevent resumption of continuing violation penalties, if any. An aggrieved party, including the town, may appeal a final order of a special master to the Circuit Court of Appeals. Such appeal shall not be a hearing de novo, but shall be limited to appellate review of the record created before the special master. An appeal shall be filed within 30 calendar days of the issuance of the order sought to be confirmed. If you are found guilty of the civil violation charge, you will be assessed an administrative fee of $100. The city representative will present their case first, and the alleged violator will present their case thereafter. I will consider the evidence and render a decision after all arguments are heard. Thank you. Is the town, may we have a roll call? We'll start.
Sure. Thank you, Brian Sherman, Interim Assistant City Attorney.
Chief Code Enforcement Officer Joseline Ramirez.
Code Officer Gene Guston.
And I am Andre McKinney, Special Master, for the record again.
Nasli Cardona, Code Compliance Clerk.
Mary Curry, Building Clerk.
Ms. Ramirez, are there any minutes for adoption?
Yes, the minutes for adoptions is for June 21, 2023.
Okay. The minutes are approved as presented.
Brian Sherman, Interim Assistant City Attorney.
Madam Magistrate, is your mic on?
Testing.
Okay, perfect.
I'll bring it closer just to make sure that we're captured. At this time, those individuals who will be presenting testimony, if you could please raise your right hand. We will be swearing in witnesses. Do you swear and affirm that the testimony that you will provide will be the truth? If so, say I do.
I do.
This is mine. And I'd like to also remind anyone, if you have entered and you have not signed in, please do so. When the town is ready, we can call our first case.
I'm sorry.
Did we
I'm sorry.
go
yes,
over item 5?
Do we have any adoption deferrals or modifications?
Yes.
Or add-ons?
We added case 7225 for an extension of time. We added case 6313 for an abatement of fine. And we are postponing case 6829.
Was that a formal hearing?
I'm sorry?
6829, was that a formal hearing?
It's a foreclosure, authorization for foreclosure.
Okay, so.
It's 12.173.
Yes. And that concludes my addition, deferrals, or modifications. Officer Jean, do you have any?
No.
Okay. Then we may continue.
Okay.
Do we have any attorney present?
Yeah, there's two that signed in.
Okay.
You want me to call it?
Number 5,
Mm-hmm.
number 7.
So we'll start with number 5, case 5465.
It's number 8.4 on the docket.
Okay. Chief Code Officer Joseline Ramirez for the town of Pembroke Park, case 5465, property owner Pembroke Crown 3 LLC, site address 2533 South Park Road, Pembroke Park, Florida. A notice of hearing to obey fine was sent by certified mail on August 1st, 23rd, posted to the property and town hall August 4, 2023. It is the town's motion to abate the fine of $54,600 and reduce it by 85%. That includes the $100 admin fee. The total is $8,275.
Good morning, Special Magistrate. Jeremy Shear representing the property owner. And I just want to give you sort of a brief summary of what's been going on this site because I don't believe you were the Special Magistrate assigned to this case in the past. We were here 1 year ago, actually, on this case. My client actually was out of the country in Israel, and it was so important to him that he called in on this case. The big ticket item for this case was the mezzanine. When my client purchased the property, these buildings are like 50 years old. The mezzanine was already there. There were building permits for Broward County. And, you know, we couldn't locate a permit from the town, but we did have a permit from Broward County. So, you know, in order to do right by the town, ultimately he decided to remove the mezzanine level. It's 2,500 square feet. That was leasable space that he gave up because he wants to do right by the town. So, you know, he lost revenue, you know, very important for the building. And, you know, I also want to note that my client held Christmas parties in the building for 20 years where, you know, the city town council members and, you know, police chief and fire chief, they would all come. And, you know, nobody ever commented on the mezzanine level. So, you know, it's only been recently that, you know, the mezzanine became an issue. But, you know, like I said, in order to do right by the town, he decided to remove it. You know, that being said, you know, it took a year because, you know, you have to get the architect, you have to get a GC, you submit the plans, it goes to the town spends time to review it, then it goes back. So it's back and forth. But my client has spent significant funds already on bringing this property into compliance. And so for that reason, we're asking that, you know, obviously we appreciate the 85% reduction, but we're asking for a 5% reduction down to $2,700 approximately, because my client has already spent, I think, over $40,000 in bringing this property into compliance for a mezzanine level that was there when he purchased the property. He didn't do anything wrong. These are older, legal non-conforming buildings. So we're asking for your, you know, empathy and understanding. And my client owns, quite a few buildings in the town. It wants to do right by the town. We want to work with you, you know, co-director, and we want to make sure that, we're all on the same page here. My client actually did just fly in from out of town as well, and I think he may have something to say as well. If you want, Tony, you want to come up?
Good morning, everyone.
Good morning.
We are trying. We're trying hard. And we've been trying for 5 years on the multiple folios that we have. Problem with this particular one, I think that there were a lot of mistakes between the folio being one folio and the addresses being two addresses. So there were a lot of mistakes as well as far as that's concerned. As far as the cost, the loss of revenue is $45,000 a year because we closed off and removed the mezzanine. As far as the cost for doing the work, we're talking probably over $100,000. But it's okay, we're trying to work. We're coming to you guys on a regular basis. It's been ongoing and ongoing. We're working with Jocelyn, and I need you guys to help us, you know, finish these things and remove these fines and help us go forward. We have other big projects that we're trying to come to the town with. We're preparing now. But, you know, all the associates and all the partners are like afraid of our town. They're afraid of what's going on. They've seen our permits open for 5 years. We're not being closed for a lot of different reasons. You know, I can't say you. So I hope that it's getting better. The new building official had really helped us move forward. Boom, boom, boom. He made us close a lot of permits. And I appreciate it. And I just got back here, so I don't even know if he's here. Is he here still?
He's here.
Okay, so again, for whatever we have left going on, we'll comply. We'll do the best that we can, but you have to give us some consideration, and you don't have to. I'm asking you to, so we can move on. And we do have other issues with this particular address that, you know, are old, and the certain things were there before we even bought the properties. We'll have to go through it with you, one-on-one. But that's all I can say. Please help us so we can move forward. I've been in this town since 1990, and I keep on buying additional properties. But here now, it's become such a difficult thing to get a permit open, to get a permit closed, okay? And we're the one that's being penalized for a lot of the changes that they decided to make. The town of Pembroke Park ran their toy run for 25 years through that Stratton building. I don't know if you were here then, but I don't know any one of you guys that were here from those days. Were you? Did you see the toy runs come through that particular specific building? Were all the fire marshals, were all the commissioners, were all the mayors? So we participated with Stratton to do this, and we donated the clothing for all the children in the back of the property. So now all of a sudden it's become such a big issue, and again, we're doing everything that we can, but time is against us. You know, when we get 90 days to comply, I stood here in one of the cases and I asked the magistrate, I told him, it's just not going to happen in 90 days. It's just not going to happen. He says, well, go do your best. So we went, we did our best, and now we're, basically finished with one issue. So, again, help us help the town become prettier. I've changed that whole block, did I not? Did I make that whole place
He
look so
made
much better?
improvements, yeah.
And it wasn't because the town said, go do this. It's because I thought, you know what, let's give this place a facelift. And we have done it, and other people are jumping in, and they're trying to comply and also do the same. So that's all. Thank you again.
Attorney Jeremy, again, your request for abatement is bringing the abated amount to what?
To 2,700, which is 5%. And I think to Tony's point, the town wants to incentivize new development. The town wants to incentivize renovations and improvement, for these existing buildings, many of which were built in the 50s and 60s and 70s. So please, keep that in consideration as a policy, from the town, not to penalize, the good ones. Tony, like he said, has been working for nonstop for over a year. Architect, general contractor, myself, other experts, in order to bring the building into compliance. So, we really appreciate your understanding in this matter.
What's the town's position on the request for a reduction to 2,700?
The reduction that the town reduces to it's the standard for all businesses and residents. We like to keep it fair for everyone. Again, is your decision if you like to accept their requests.
Thank you for your presentation. Based on the information provided, I will reduce the abated amount by $2,000, bringing it down to $6,275. That does include the $100 assessment. In light of your information and testimony provided,
Special Magistrate, could we reduce that a little bit more, bring it down to $4,000? We'd really appreciate that.
we cannot. The town has been quite generous, and I've taken $2,000 off based on the efforts. I've heard the property owner. The town has not rebutted the efforts made. You've testified that you've worked with the building official and bringing things into compliance. So I think in totality, that amount is quite fair.
Say something. Look, it's not even the money issue. It's not. It's just so wrong that we are being penalized for so many things. And again, it's not one folio. If I brought in the chart right now, it would be the size of that television with all the folios and all the permits and all the violations and repeated violations. It's 100% wrong. We shouldn't be penalized at all. We should be given the time to do what we need to do in order. Look, you want a donation to the city, it's okay. We'd love to donate, but it's like basically strong-arming us and putting us in a position where you have to do this in 90 days, and if you don't do it, you're gonna get a $50,000 fine. I'm telling you, partners, associates are looking away from the town. I'm trying to do big things here, and I have done big things here, okay? The corner of the storage facility on Park Road, that was my land from 1990. I got it approved by the town, it's standing up. We have another one next door to us right now, the 2727, that's gonna be possibly 160,000 square feet. How do I move where the town is with us rather than coming against us? And if we're not able to comply because of architectural drawings and bringing back and forth with the town, you guys didn't have anybody to help us. The town building official now, he's like Jesus Christ showed up. He walks in and he looks at it and he moves and he moved. We didn't have that for 5 years. It's not our fault. It's not our fault, and we're being penalized, you know, with these type of. One of the I shouldn't bring this in, but then again, it's all inclusive. 27. We had to do a permit again for something that was finalized 3 years ago or 2 years ago. So, you know, I kept quiet. I said, pay the fine, pay the fee. It was $875 for something that was open and closed. It was a big conglomeration of issues there, but it's done. So, you know, to $45,000 a year is lost revenue because there was not a staircase for that mezzanine. You know, this is wrong. If that gentleman was in the place, if the building official was there at the time that this thing started, this would never happen. It would never happen. So I really think that you need to help us as much as you can. And $6,000 for penalized on top of penalization, it's wrong.
That's a reduction from the $54,600 that the city reduced it to $82.75. And I've taken $2,000 off in light of everything that you've shared and your mitigation or abatement application. The city codes are in place to ensure the safety and welfare of everyone, and I have no doubts that you worked earnestly to bring the property into
The
compliance.
56,000 shouldn't have been there and shouldn't be there. It's wrong. We are part of the same house here. You are my town, I am your, you know, tenant or whatever you would call. I'm an owner of the property. I can't vote for anything because I'm a commercial, but I own 100,000 square feet here, and we're getting bombarded for every single address. It's like an attack on us. It's wrong. We didn't come back and say, hey, guys, you know, we're going to do anything against the town. We want to stay together. We want to work with you guys because, again, we have big projects. But it's to me, it's abuse.
And Officer Ramirez, does the town offer payment plans for these abated amounts?
We can offer about 120 days to pay for it.
Okay.
That would be the max that we've ever given. But they can make payments within that time frame, but they do have to do it before the 120 days.
Okay.
And I just like to add, yes, you are right, Mr. Ross, that you did work effortlessly, but I just want to notate that this notice was given back in December 2020 during the pandemic, and we did remain open during the pandemic. And then we didn't start accruing a fine until 2022, October 22, 2 years later from
During the pandemic, it
date
was,
of the notice. So we have given substantial time to comply.
during the pandemic, how difficult was it to get to you guys? You say you were open.
The
They told
building
us to stay
department
home.
remained open.
Yeah, they told us to stay home and not to come in, and it was a shmei dre. It was a.
And that's why we gave 2 years before we started a fine.
Listen, it's wrong. That's it. That's all I can say. I'm not going to argue. I'm just telling you it's wrong. We shouldn't have
I
been
agree.
charged 56,000 on this one, 75 or 60,000 on another one. I mean, we're getting bills for 50 and 60 and 70,000 dollars for violations that we cannot close. We cannot close for multiple reasons. I could sit with you and go through them, but it's not the $6,000 here. It's the general picture. How do we handle this? And I came here in front of the magistrate and I begged him. I said, please help us, help all of us to get this thing resolved, and so we can move the city and ourselves forward with compliance. 2525 is one of the buildings. We can't even rent it because the marshal wants now a door in between doors or build a corridor, which will destroy the whole warehouse. It will just make the warehouse useless. So now we have multiples of these. We are being put in a position where we cannot collect $3,600 rent. It's been sitting empty for how long? Almost 6 months? Right there is 20,000. It's just it's not the money, it's the principle behind it, that we're losing so much money trying to comply, and then we have to have fines. You know, so, look, he made the offer of the 5%. I didn't argue and I didn't say anything. I'm okay with that. I would like for you to consider that amount, and that should be the end of it, and we'll pay it within a month. I'll give you 2 payments or something, we'll do it.
Madam Magistrate, I know you made a ruling 6,270. Does that still stand?
If the town,
The town position remains the same. Again, we'd like to be fair to everybody and hold the same
yes,
standard.
and so my further abatement stands.
Ms. McKinney, how many days would they have to pay?
Based on what the town has indicated, I have no issue in ordering payment within 120 days, which I think is the longest that I've seen.
All right, thank you for your time. Please, Jocelyn, will you email us the order? All right.
And let me just announce my oral pronouncement for the record. Based on the testimony and evidence presented, there is substantial and competent evidence to support the city's position and my reduction amount. The fine amount is hereby abated to $6,275. That includes the admin cost of $100, which must be paid within 120 days. Failure to pay the abated amount of $6,275 will cause the fine to revert to the original amount imposed.
Great. All right, thank you.
And if you wait a moment, they'll give you a copy as well. Hand you a copy.
Thank you. Ms. McKinney, may I call the next case?
Yes.
The next one I have on the docket is 4993 Howard Clark, counsel for Lakeshore Mobile Home Park LLC. It's number 8.2 on the docket. This is also a hearing to abate fine.
Chief Code Officer Jocelyn for the Town of Pembroke Park. Case 4933. Property owner Lakeshore Mobile Home Park LLC. Site address 2701 South Park Road, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail August 1st, 2023, posted to the Property and Town Hall August 4th, 2023.
Howard Clark with the Law Office of Robert N. Hartzell on behalf of Lakeshore.
Good morning.
Good morning.
Okay. It is the town's motion to abate the fine of $72,167 and reduce it by 85%. That includes the $100 admin fee, the recording lien fee of $58.50, and the release of the lien, which is $8.50. The total is $10,967.
Special Magistrate, we would just ask you to consider the violation, especially the last one that we corrected, was security cameras, which is a safety thing. And that would be the only consideration I have for you. Besides that, we would be happy to accept the town's 85% reduction to $10,967. Thank you.
Okay, well, hearing the agreement as to the amount, based on the testimony and evidence presented, I find that there is substantial competent evidence to support the city's abatement position as to the amount of $10,967. The fine is hereby abated to that amount. You have 30 days to pay that. Failure to pay.
Could we ask for 60 days?
Does the town have an objection to that?
No.
Okay, 60 days to pay. Failure to pay will cause the original fine amount to resume.
Thank you very much. Have a great day.
Good luck to you. We can scratch it out, yeah.
Sir, can you wait for the copy, please?
Okay.
Yeah.
I initialed it. You're welcome. Yeah. And right here. We'll do.
So we got this one over.
It's clearer right here.
Any more attorney present? Okay, so we are going to go in the order of the agenda.
Next case would be 5716. Number 8.3 on the docket, First GRD Property, Inc., located at 5520 Southwest 33rd Street. This is a motion to abate fine.
Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 5716. Property owner First GRD Property, Inc., site address 5520 Southwest 33rd Street, Unit 1 through 2, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail, July 21, 23rd, posted to the property and town hall August 4th, 2023. It is the town's motion to abate the fine of $27,350 and reduce it by 90%. Give me one moment. That would be a total of $2,825, and that includes the admin fee.
Good morning. Your name for the record and your position?
My name is Rose Delva.
And I'm Gaston Delva, the part owner of the business property. We respectfully ask you, Your Honor, to further reduce the amount because we spent a lot of money to renovate the property, and we max our credit card. And for more than 2 years, we didn't make any revenue on the property. We did the best we could to comply with the town, but unfortunately, we had initially some bad advice. Then we rely on some professional who did not deliver on time what they promised to us. That's why we end up by getting that fine.
The town has reduced the amount to $2,825, which represents 90%.
Yeah, I will appreciate it, Your Honor, if you can reduce that further. We're really out of.
Just so I'm clear, are you guys the owners or of First GRD Property, or are you the managers?
We are the owner.
Okay, you're the owners? Okay.
Yes.
But it is a duplex. It's residential.
Okay.
And they did mention that it's been vacant for quite some time.
More than 2 years.
And they did have problematic tenants. The property does look very beautiful. They did major improvements. But that's why the town is holding it as a residential reduction, which is 90% versus the 85%.
And the town's position with regards to a further reduction as to the generous amount that's been given already?
Again, we want to be fair to everybody, so we can only do 90% per resident.
Your property is owned by an incorporation, and based on the testimony provided by the officer, the town has granted 90% when the reduction would otherwise be 85%. Am I correct? So you've already gotten a further reduction in light of everything and what the town has testified with regards to the tenants, and your testimony with regards to an untimely delivery on services. Based on the testimony in totality, I will reduce it by $800, which would bring your total abated amount to $2,025. And that will have to be paid within 30 days. The administrative fee of $100 is included in that amount. Failure to pay will cause the entire amount to resume to the original amount. So.
We take it.
Okay.
Copy that. I appreciate that. That's nice.
Thank you.
Based on the testimony and evidence presented, there is substantial and competent evidence to support the city's position as to abatement and a further reduction of $800. You are hereby ordered to pay $2,025 within 30 days, or the original amount of the fine will resume or revert back. Good luck to you.
All right.
Appreciate it.
Thank you.
You're welcome.
Thank you.
You're welcome. If you could just stand right there, and we'll provide you with.
Thank you, Ms. McKinney. The next case is going to be on 12.1.1 of your docket. Case number 4763 is Jesus Jaime Rodriguez and Lydia Rodriguez. This is on the town's motion to authorize foreclosure.
Assistant Town Attorney, being that there's another case on the agenda, would you like to call that? And if the city the town would then move to have the list approved, or how do you want to handle that?
We can go through this hearing, and then if you would like, we can call the second one. And I'll read it into the record now, which is 4795, which is 12.1.2 on the docket, Jalen Puello. We just have to go through that case and notice for that hearing.
Okay. Thank you.
So we can present the first case.
There's no presentation. This is just a list for the Madam Magistrate to approve. For foreclosure, these properties are not homestead exemption. The lien that was recorded is past the 90 days. So we would like the Madam Magistrate to approve this list for foreclosure.
And was notice given on notice of hearing sent to both property owners at the address listed on the property appraiser's website by certified mail?
Yes.
And one last, and for the record and the benefit of the respondent who is here, the property as of to date remains not in compliance?
Yes, not in compliance.
Okay. Good morning. Please state your name and your position.
Yeah, I'm sorry, I speak English.
Okay.
Madam Magistrate, we do not have a translator today.
Okay.
I can help him.
Ella va a traducir lo
Okay,
que...
one moment.
Sí.
Can you just state your name on the record, and you'll be providing interpretation for him?
Yeah,
The town-
Maite Almeida.
Okay. Does the town have an objection to a member of the public
No.
interpreting? Okay. If you could ask him to please state his name on the record, his full name, and what is his position with regards to the case today?
Tu nombre completo, que lo diga.
Ok, Jesús Jaime Rodríguez.
¿Y cuál es tu posición en lo que te están proponiendo?
Ahorita mismo no sé lo que ustedes quieren de tomar conmigo, si...
Pero,
No.
¿qué es lo que tú quieres hacer?
No, que es lo que quieren hacer ellos conmigo, porque no sé todavía lo que quieren hacer conmigo.
He doesn't know exactly what the city wants from him.
Okay, well, the item on the agenda today is to approve a foreclosure list of properties that are non-homestead, have a code violation not in compliance, and also have a code lien recorded and has been recorded greater than 3 months. Florida statute authorizes a town, city council, or city commission to authorize the foreclosure. This part is just to authorize this property to be placed on a list.
Ellos lo que quieren autorizar es un foreclosure en la propiedad porque no está en compliance con lo que ellos están pidiendo.
Ok. Ella va a traducir lo que yo le voy a decir, no tengo represalia con ella.
He say I'm going to translate whatever he say and it's nothing that has to do with me.
Okay.
Yeah.
Lo que pasa es que ya lo que tienen aquí es personal conmigo porque hay más de 95 trailers con violaciones en mi campo de trailer.
Let me see. what he says like this is something personal because it's more than 95 mobile homes with violations.
Ya que yo he denunciado toda la corrupción anteriormente de todos los políticos que eran dueños de los campos de tráiler, que todavía hay más de 10 campos de tráiler que tienen violaciones.
So he has complained about all the stuff that's been going on with the politicians. ¿En qué más?
De todos los políticos han tenido violaciones también de los campos de tráiler.
And all the violations with all the mobile homes.
Quisiera saber dónde están los canadienses hoy, solo los latinos y los negros los que estamos aquí.
He wants to know where all the Canadians and
Los latinos y los negros.
and only Latins and black people are here in this moment for the violations.
Hay 10 campos de tráiler que son de canadienses, no tienen ni una violación y tienen los pisos en la tierra.
There is ¿cuánto?
Hay más de 10 campos
There
de
is
tráiler.
more than 10 mobile homes.
Más de 10 campos de tráiler que hay alrededor de 1,000 mobile homes que tienen violaciones y no hacen nada porque son canadienses.
They have violations and they are on the ground and nobody has done anything about it.
Hay pruebas suficientes de eso que lo tiene el gobierno federal porque yo lo he denunciado con el gobierno federal.
Before you translate, can you please translate this?
Yeah.
And so the point at which where we are
El punto que ellos están tratando de expresar
is that
es que
the property owner has not
dueño de la
come into
propiedad,
compliance after having received a notice of violation, after having had an final order issued, after having had an order imposing fine, and after having a recorded lien remain on his property, according to the file, greater than 5 months. And so we are at the point where compliance has not been achieved. The purpose of our meeting today is to approve the city's list. The code officer has already testified as to notice being provided. He is here. The property remains not in compliance. And for the reasons that I've set forth, which is in the file, this property is on the list. So that is the purpose of the hearing today. And I'd like to also add, if he would like to submit a complaint identifying himself and the existence of violation, there's a process for that, but this is not the venue for that.
La otra cosa que quería decirle que
The
yo no
other
he
thing
cumplido
he
con
wants
ellos
he wants to say is
porque yo
that
estoy
he
enfermo de cáncer,
he hasn't complied with what you guys asked because he has cancer
estoy deshabilitado por el
and
Social
he's
Security.
in disability for the Social Security.
Tengo 3 niños que son enfermos
He had 3 kids that are being sick.
que requieren atención médica
They
todos los
need
meses.
medical attention every month.
Y he venido a explicar varias veces eso. y
And
no
he
me
has
hace.
been explaining that a couple times.
Ok, sin embargo, hay 95 trailers que tienen más violación que la mía
But
y no los veo aquí a ninguno.
regardless of all these issues, it's like more than 95 mobile homes, so it has violations. And
Yo me estoy creyendo entonces
And
que como yo
he's-
denuncié a
he's-
todos esos políticos que
he's
eran
believing that because he made an announcement to all these politicians
corruptos, entonces eso es lo que
and the
está
corruption,
pasando.
that's why they against him, like he feel discriminated or
Yo
something.
voy a empezar de nuevo con el gobierno federal.
So he's gonna start with the government, federal government, and
Gente que representan a la gente.
the people that represent people like him.
Voy a ver todos los códigos de todos
And
los
he's gonna
campos de
check all the
tráiler
codes and the ¿el código de
Tallahassee.
qué? En Tallahassee.
Aquí enfrente este campo de tráiler está ilegal completo porque no tiene los.
This mobile home, where
Aquí
is?
enfrente.
Right here in front of us.
Madam, Miss Interpreter, again, if you could,
Espérate, déjame decirle.
if he'd like to make a complaint identifying himself in whatever violation, this is not the
Si tú
process.
quieres hacer todo eso, hay un
Yo
proceso
quisiera
que
como
tienes
yo
que hacer.
pudiera pasarle todo ese proceso a ella para que vea todo lo que está
How he
pasando.
can file all that process to you, like
It doesn't go to me.
no sé,
It
eso
goes
no
to
va
the
para
city.
ella.
The other thing that I
Para
want
la
to
ciudad.
say to him is, And
La otra cosa que ella
I
quiere-
apologize that he's going through cancer and all of the issues that he
Dile
identified.
que la señora Joseline sabe mi problema como es con mis hijos, que los tengo enfermos.
However,
Una persona enferma.
However, what he needs to do
Lo que tú tienes que
is
hacer es
to try his best to
tratarlo
bring
mejor.
the violations into compliance.
De
I'm going
ponerlo-
to grant the city's motion with regards to approving this property on the list. And
Para que
he
se apruebe.
is strongly encouraged to work with the building department and the other officials in assisting him to bring the violations into compliance.
The building para que te den
Thank you, Ms.
asistencia.
McKinney. Does that also include 4795 12.2? We call both cases.
Okay, and for the record, can,
Y para el récord.
for 4795, can we just, for the record, Officer Ramirez, notice was duly served on that property, an affirmative yes on the record? I see
Yes.
the nodding, okay, awesome. And the lien has been recorded on the property greater than 90 days,
Que el link que
Correct.
pusieron-
and the property remains not in compliance.
Correct.
Okay, so my pronouncement is also applicable to 4795. That also is the city's, town's motion to have that property placed on the foreclosure list as well.
Que el otro caso que tienes puesto es que quieren poner la propiedad en foreclosure.
Can you give her the order, please, to sign?
So, Mr. Jesus, we've heard your case.
Vamos a escuchar
I've
otro ca-
rendered granted the city's motion to have this list approved with the property. Again, you are strongly encouraged and urged to bring the property into compliance.
Estamos como diciendo que trates de poner
We can
la
call the next
propiedad,
case when you're ready.
Sure.
Dentro del código.
The next case would be 6137 Angela Esposito, case number 10.5 on the docket. This is at
quieres,
2303
espera,
Southwest 31st Avenue,
Y ahora le toca a
Pembroke
ella.
Park.
Entonces quiero...
And this is a first-time hearing, Officer Gene Guston.
This one is
Code Officer Gene
Ya terminaron
Guston
con tu-
for the
Ya,
town of
ya,
Pembroke.
yes,
Yep.
yes.
Ahora con los papeles aquí, ¿no?
Sí, que te den una copia.
Officer Ramirez,
Déjame que
just
tú-
to,
tú no
six,
hagas-
case 6829, that is not a part of the approval of the motion to foreclose list.
Correct. That case was postponed.
So we'll take that off. Okay. You're welcome. Good morning.
Good morning.
Good morning.
Déjame hablar.
Code Officer Gene Guston for the town of Pembroke Park.
Sí, pero no hablo.
Case number 6137, property owner Angela Exposito, site address 2303 Southwest 31st Avenue, Pembroke Park, Florida. The notice of violation was sent by regular mail on August 9th, 21.
Speaking to them.
August 9th, 2021. A notice of formal hearing was sent by certified mail with a copy of notice on July 7, 2023, and posted to the property on August 2nd, 23, and in Town Hall on August 4th, 2023. The violations for item 1, wooden fence installed without permit. Item 2, verification of occupancy in a mobile home. Item 3, concrete steps installed without a permit. Item 4, wooden deck at front patio areas installed without a permit. Item 5, sliding glass door at patio area installed without a permit. Item 6, windows installed without a permit. Item 7, wooden rail at side of mobile home installed without a permit. Item 8, concrete pavers, slab built without a permit. And item 9, chain link fence and post installed without a permit. At this current time, as of July 7, 2023, there was an affidavit of compliance. My recommendation is to give 30 days to comply or a daily fine amount of $100.
Oh,
We're
este fue el
on
que se lo puso.
6137. You're reading the right one?
No.
Yes, that is the right one.
Let me make sure it's the right one.
Ahora.
You said 3, let's make sure.
My recommendation is to give 30 days to comply or a daily fine amount of $100 per day after with a $100 admin fee.
Good morning again.
Good morning.
If you could state your name for the record and your position with regards to the violation.
My name is Maite Almeida, and that's my mother, Angela Esposito. So,
No.
what she was trying to explain, she brought...
Yo hablo, tú todo.
Okay, well, she wants to talk.
Okay.
All right.
Okay.
Dime, a mí.
This is my lawyer. This is my daughter. Okay?
God.
Can you please speak into the mic?
Que hables en el micrófono.
Yeah, sorry.
Háblame a mí y
Sí.
Can you state your name for the record?
tu nombre, Ángela Esposito.
My name is Angel Esposito. Yo compré este mobile home
She bought this mobile home
en unas condiciones paupérrimas,
in really poor conditions,
donde las ratas
where
de este tamaño,
the rats were this big,
donde 10 años nunca se limpió el mobile home,
when in 10 years that had never been cleaned,
donde la basura estaba en los closets por 10 años,
where the trash were like hiding in closets for over 10 years,
donde el peligro de toda la comunidad que estaba cerca
When-
del mobile home
when this was a hazard for the whole community because the conditions,
peligraba por el exceso de animales de roedores.
because the excessive rodents around the mobile home.
Nunca, nunca,
Never
nunca
Never.
se paró la ciudad
no
a
no
poner
one from the city has stepped
Una-
by
una
to
violación.
put a violation on that property before.
El dueño del parque,
The owner of the park,
cuando me vio limpiando,
when they saw me cleaning,
que me pasé casi un año entero,
that I was like one entire
prueba.
year cleaning.
aquí tengo las pruebas.
Show it to the code officer first.
Yes.
So this is the proof of how she found the mobile home and the conditions, like the horrible conditions they were before she got the violations.
Dijo, si yo sé esto, porque ahí olía
And
animal muerto,
then the owner of the park said that he knew this before because it smelled like a dead animal.
yo hubiera mandado a tumbar este
I would have demolished the entire place.
Entonces,
Dean, can you pass me the ones you've seen?
Mami, pero
These are the
tú vas a hablar. Ajá, continúa.
yo creía que solamente el yo llegar ahí y reformar, limpiar e higienizar mi mobile home ayudaría a la comunidad.
I thought like cleaning up and making the place look better, it will help the community and make everything better for everybody at the same time.
Todo lo contrario.
But it has been reversed for her.
Hubo un vecino que le causó
It was a neighbor that
odio, envidia, no sé.
it was a neighbor that somehow got envious or jealous of
Iba pasando la supervisora, que no está aquí ya.
It was the supervisor at that moment, compliance, passing by,
Y la llamó
and he called her out
y le dijo, venga
and come over here
para que vea todo lo que esta señora ha hecho aquí.
so you can see what this lady have done in this property.
Yo trabajaba 12 horas diarias.
I was working 12 hours a day.
Yo tengo un brazo partido, una pierna partida, de
I
tanto trabajar.
I
Tengo
have a leg and arm with previous fractures.
Tengo 74 años.
I'm 74 years old.
Debía estar en mi casa descansando.
I should be at home resting.
Tengo que trabajar para seguir reparando un
I
trailer.
still have to work to continue fixing the mobile home.
Pero
But
todo el campo de trailer
the whole mobile home
tiene violaciones graves.
has very bad violations.
Construcciones de cemento,
Cement constructions made out of cement,
muebles en los jardines.
furnitures everywhere, outside, inside, everywhere, like in the garden.
Que conozco una
Excuse
persona.
me. May I remind you, we're discussing case 6137. If she wants to make a complaint of other properties, she has to come to our office to make a complaint.
Un complaint de las otras propiedades, tienes que, pero que estamos enfocándonos en tu caso.
Está bien. Yo no voy a hacerlo Porque ese
I'm not
trabajo
gonna
es
do
de
it.
ustedes.
This is just you
No
guys'
es de
job.
una, de dos, de tres personas. Es un
I
campo.
have a few questions. And I understand her point through your interpretation. Thank you. When she purchased this property, was she living in this property?
No, no. When she purchased the property, no, she was. ¿Tú estabas viviendo cuando tú compraste la propiedad esta? ¿Tú estabas viviendo ahí?
No.
Adentro.
Adentro, claro, toda la vida viví de ella.
No, pero cuando tú la compraste, tú empezaste a
No
vivir
pude
ahí.
vivir hasta que
No,
no la
she
viví.
started cleaning, and then after she cleaned the whole property, then she started living on it.
Okay. So by her testimony and the photos that she's taken, clearly there's some issues existing at the property at the time she acquired this piece of property. And while she may not have created the condition
Yeah.
that she purchased, right? This was a purchase. I recall her testifying that when she purchased it, it was in this state. And unfortunately, you know, when you buy a piece of property, you take the good and the bad along with that, and you become responsible for that. And so it's good that she is bringing it into compliance, but it doesn't change the fact that violations exist.
No, I do understand that part, that whole part. But one of the things that I kind of see looking at the stuff that she did and now is that a lot of the violations, it had nothing to do with her. They were there.
Right.
Yeah, no, I know. I know what you're saying. That
when she finished.
I know what you're saying. Like she say also that there's also other complaints about other people, but it's like every single property has cement stairs that I have going everywhere, every single property. And all of a sudden, this person is trying to make a property better for the whole community, for the city. It's actually should be a good thing. And now she's facing all these violations all of a sudden when the other person that never take care of the property was there and never have violations. And now this person, because somebody else across the street didn't like her or whatever, have something against her, now she is in this predicament that she has to pay all these violations when she is trying to do something better for herself, the community, and the city.
And I understood all of that.
Yeah.
And,
If I may?
yes.
Sure. In this situation, as Ms. McKinney and Ms. Ramirez have stated, that we're dealing with just your property. Just because the other violation or the other property that you claim is in violation, you can either make that report, and there's even a chance that that property is actually already going through this process. We have these meetings every month. So there could be a pending violation against that. And if there isn't, then Ms. Ramirez and Mr. Gustin will be happy to look into that. But right now we're dealing with your property and what you need to comply. So
we do understand that those violations exist.
Okay.
They're there because they put it in the paper and all that. But before she moved there, they were never there.
Well, as far as owner of the mobile home, it's your responsibility, and there are applicable provisions of state law. There's applicable provisions of the building code. You need to work through those.
Yeah.
So the next question would be is how much time you would need to comply with those violations.
That's the thing. Okay, she's willing to comply with violations to do whatever. I'm actually gonna help her to remove whatever needs to be removed. But the thing is that right now she's not even working, and so she's not even working, and she needs. She has lost a lot of money investing in this property because all the money she put into it to fix things. So
It comes down to, again, we have to have compliance with the building
Yes,
code and
I
the
agree.
town code. So how long would you need in order to achieve compliance? 30 days, 90 days, 60 days?
like at least the maximum that you can offer to comply with this, the maximum that you can offer, because she will have to count with my help and my time off.
Would you be able to do it within 90 days?
Yes. Yes. except for the stuff that she had to be replaced with money. I don't know how we could do that. Like some stuff that they put there about a window. The window was there.
Permission. I have permission.
You have permission for the window? Okay. I don't know in reality the amount of money that she's gonna need or to fix these things, but in whatever is in our power to remove or replace.
Well, it's just a matter of getting the windows
That means from the park.
permitted. You know, it might take a lot, it might take a little. The answer is we don't know.
Yeah.
You have to speak with the building department. So would 90 days be enough time for you to complete anything? And then after that, you could speak with Mr. Augustin if you need additional time.
If we didn't need additional time, yeah.
Ms. Exposito said that she got permission for the windows. What does that mean?
I pay here.
You came to the building department and you got a permit?
Yes.
Okay, do you have documentation of that?
¿Algún papel que te diga de eso?
No. Sí, como yo pagué, pagué los permisos siempre.
Well, even if you have a permit, you have to get the inspections. So there's two parts to the permit. You pull the permit, and then you have to get the final inspection to say that everything matches the building code. So there's two parts of it,
Okay.
which is ultimately for compliance. So
Yo pagué permiso para hacer la ventana, pero la escalera esta que estaba aquí, esta escalera
No,
que
that's-
estaba separada.
that's different.
El de Building Department me dijo, arregle la escalera porque usted se va a caer por la escalera, arregle primero. Y
So
después arregle la
she paid for the window permits, and then the person from the building department told her, you need to fix the stairs because you're gonna fall because it was kind of like crooked.
Okay, so if she got permits, she needs documentation of that. She needs to get with Officer Augustin and provide those evidence
Okay.
that she got permits for those items.
Ms. McKinney, we would suggest that you find the violations as presented and allow 90 days to comply.
Okay.
Based on the testimony and evidence presented, there is substantial and competent evidence to support the city's position. You are hereby ordered to comply, bring the property into compliance within 90 days or face a per diem fine. What's the town's recommendation per diem fine?
$100 per day?
Or face a $100 per day daily accruing fine.
Okay. So when she finished all these fixing all these violations, then she had to come here. Or how is the process work?
If she doesn't fix everything, if she has a permit, she's going to have to call for inspections, make sure the permit is closed, notify the code officer the property is in compliance so he can close the case.
Okay.
All of that has to happen in 90 days.
90 days. Okay.
If not, the $100 per day fine will start adding daily.
coming. Okay.
There's also a $100 administrative cost assessed for today's hearing.
Okay.
And then I'm going to return the photos. If she wants this a part of the record, she'll have to make copies.
Madam Magistrate, if the photos were submitted and you considered those and they are part of the record, then we need to keep those. Are those copies we can keep?
¿Tú tienes copia de esa foto? No.
That we can either make copies, but if they were submitted into the record for consideration, they are part of the public record.
Porque ellos quieren quedarla para.
Leslie, can you please make copies
para
of the
parte del
photos
récord de
so
ellos.
we can have them in record? Yes.
Remember at the beginning I said evidence you present becomes a part of the hearing file.
Yeah.
Take a picture,
Sí.
ahí está el picture con el celular.
Ah, ok.
Ahí
Sí.
take a picture con el celular.
Entonces están en el celular tuyo.
No, stay now.
It's okay. We'll make a copy of it
Okay.
to submit it in the record.
Ahora, ¿qué dice? Que 90 días tengo.
Sí, pero para arreglar las cosas y después pues, vamos hablamos
Madam
con él
Magistrate, may
otra
I
vez
call
de
the next
nuevo.
case?
Yes, you can stand right there. You get a copy of the order.
No, yo le pregunté
The next case is 11.1 on your docket, case 6123. Isaac Levy, case 4900 Southwest 36 Court, Pembroke Park. This is a hearing to confirm fine from Officer John Gustin.
Code Officer Jane Gusson for the Town of Pembroke Park, case number 6123, property owner Livy Isaac, site address 4900 Southwest 36th Court, Pembroke Park, Florida. The notice of violation was sent by regular mail and posted on the property August 4th, 2023. It was sent by regular mail and posted on property on August 4th, 2021. A notice of hearing to confirm fines with the copy of notice of violation was sent by certified mail with a copy of notice of violation on July 19, 2023, and posted to the property on August 2nd, 2023, and the town hall on August 4th, 2023. The violation is for item 1, AC meeting split installed without permit. At this current time, as of July 19, 2023, there was an affidavit of non-compliance. The property is not in compliance, so is the town motion to confirm the fine amount of $12,100.
Good morning. Can you please state your name and your
My name is
position?
Emi Sapir. I'm the property manager,
Okay.
Mr. Isaac Levy. I didn't really understand. There was a violation for two things, something with paint and a mini split that was put with no permit back in 2021. Both of them were taken care of right away within a few weeks. And then I spoke with the code compliance officer. She left ever since. She left right away. So I don't really understand. Is it about to pull a permit to take out the mini split AC?
Correct.
Or this is the only thing we have to do?
For right now.
Comply.
Yes, you already did the paint.
Right.
Yes.
It was
so
a long time ago. And we took out the AC. The AC is not there. It just they didn't pull a permit, I understand.
And they also installed a new AC, correct?
I'm sorry, what?
They also installed a new AC?
There's a central AC in the house. They just added one for one of the rooms because the tenant said it's hot there or whatever. Once we got the violation, it's been taken out.
Okay,
There is a central, you can inspect the house if you want,
okay,
from when they built the house. So for now, I just need to pull a permit. I just want to understand.
yes. And after the fact permit, because you said that it's been removed?
Yes.
Yeah.
Long time ago, back when we had the.
It was 11,800, right?
Yeah, so after the fact permit with the building department, if you are the property owner, you can do a homeowner permit,
Okay.
okay?
Just to remove the AC.
Mm-hmm.
All right.
Okay.
How much time I have for that?
The case here today is to confirm the fine of $11,800. This is not a formal hearing. That already passed. So no one brought the property into full compliance, and that is why we're here today, to confirm that fine amount. Fines have been running, and that's what we're confirming today, and they will continue to run at the daily amount until compliance is fully achieved.
And then we'll deal with the fine.
You can file an application for abatement with the town.
All right.
Yes.
Thank you very much.
And Mr. Gustin is managing your case, so he will be happy to provide any information you need about the case. And just let him know when you get that after the fact permit, be in communication with him, okay?
Gonna do it this week. Owner permit, right? Does he have to live there in order to, it has to be homestead in order to have an owner permit, or we can do it?
You'd have to ask the building department.
Huh?
You'd have to ask the building department on who can actually fill it out.
Okay, I'm going to give my oral pronouncement. So based on the testimony and evidence presented, there is substantial and competent evidence to support the city's position to confirm the fine in the amount of $11,800. That does include the $100 administrative cost. If you fail to bring the property into compliance, the daily fine amount will continue to accrue. You are also assessed $100 for today's hearing. Okay, you're welcome. Good luck to you.
Thank you. The next case on the docket is 8.6, case 8354, Eno LLC, located at 511 Southwest 25th Court.
Chief Code Officer Jocelyn Ramirez for the town of Pembroke Park, case 8354, property owner Enco LLC, site address 5411 Southwest 25th Court, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail July 21, 23rd, posted to the property and town hall on August 4, 2023. It is the town's motion to abate the fine of $600, reduce it by 85%. The total amount is $175. That includes the 100 admin fee.
Good morning. Can you please state your name for the record?
Wilson Sanchez.
Mr. Sanchez, what's your position with regards to the reduction from $600 to $175?
Yeah, we accept that.
Okay.
Thank you.
So my oral pronouncement is, based on the testimony evidence presented, there's substantial and competent evidence to support the town's position in abatement from $600 to $175, which respondents in agreement of. You have 30 days to pay the final amount. Otherwise, the amount will resume or revert back to the original amount.
Okay.
Okay. If you can stand right there, you'll get a copy of the order.
Thank you.
The next case is on 10.2 under docket, case 5552, Maria G. Ortega, 3100 West Hallandale Beach Boulevard, lot 203. First time hearing code officer Jean Gustin.
Okay, we're gonna take a little pause on, are we up to date with the documents?
I'm trying to do it.
I understand. Just asking if you need some time.
Yes.
Okay, 5 minutes, okay.
Thank you.
Because she was making copies of the photos,
Okay.
so just a little quick pause.
Pause.
No. This is case number.
Okay.
Morning.
We're taking a little quick pause while we can get everybody's documentation, okay?
Okay.
Esto no es complicado, es
Están
solamente,
haciendo una pausa porque tienen que chequear unos documentos ahí.
esto es solamente para yo sacar una extensión del caso, para yo poder obtener un contratista,
Oh, okay.
para poder sacar los permisos que necesito.
Okay.
Creo que no sea complicado.
Okay, no.
Speak into the mic if you have a question.
I'm speaking back. Okay, we're recalling case number 6123, property owner Isaac Levy. Mr. Levy, I want to correct my oral pronouncement. The fine amount that's being confirmed is $12,100. That includes the $100 fine. I inadvertently said $11,800. That is incorrect. It's $12,100, which includes the $100 admin fine. And again, if that amount, if you don't come into compliance, that amount will continue to accrue at a daily rate of $50. Okay?
Ms. McKinney, this is Mr. Sapir. I think he was the property manager. You see, you call him Mr. Levy, and just want to say.
Oh, I thought he introduced himself as Mr. Levy.
No.
Oh, okay. You're here on behalf of Mr. Levy?
Yes.
Okay. Okay, perfect. This one is good. I didn't get the other order for the other gentleman.
How many orders do you have already? All right, so get all the 3 and then make a copy.
Yeah.
I'm looking at the file.
We do have
Here's the folder.
No,
Which was
the electronic file.
the last case? Case it was an abatement?
Mr. Sanchez. That was the one before Mr. Sanchez.
Oh, here it is. 6123?
No. That one is for the representative for Mr. Levy. Mr. Sanchez is the one leaning on the wall. I haven't signed anything for him yet. It's an abatement.
Can that just, can that printer scan? Because if anything, we can just scan it to, one of your emails, and that's fine too.
Mr. Sanchez, what's your case number again?
But it doesn't.
8354.
Oh, okay, wonderful. Can we bring it upstairs to the clerk's office and have them scan it? Okay.
It's an abatement. Okay.
Okay.
No worries. That was 175, 30 days.
Is there a department that has a scanner that we can scan it to our someone's email?
Yeah, Jeffrey has it.
up front right now, and he said, go ahead and do it.
Okay. That would work.
If she laid like four photos at a time.
Oh. So it got jammed.
Well, you
Oh,
can't,
yeah.
you can't run them through. You've got to lift up, yeah.
Like paper to
Yeah, because
Did she put the 4 photos?
I'm not sure.
Go check with him.
Oh, it's a paper jam. It jammed.
Have the blue and
Oh,
it
so-
doesn't print it. You forget? Oh, thank you.
Do we need color though? We try to save the color ink and just print in black.
Okay, Miss Lou.
Yes, absolutely. Good time for a bathroom break. Looks like the walls are freshly painted. Looks a lot brighter in here.
Yeah, it is. Because they took the
They took this stucco, the design on the wall.
Is that the original?
Yeah, it's the original.
Finishing?
Yeah. But I don't know. It almost looks like a primer though. I don't know.
Yeah.
If that was the final coat.
Considering things are still covered, probably not.
Really?
Mr. Sanchez? Oh, okay. Juggling many things.
It's a loading.
Yeah, we heard, yeah.
Yeah.
Yeah. And so the last one we heard was 8354, so we're gonna go, well, what city are you from? Oh, no, I mean for, you worked as a code officer?
Yeah, no Florida.
Oh, North Lauderdale.
Yeah.
That's a small little town.
Yeah.
What's the population?
We're under 50,000. Yeah.
His case, the red t-shirt, is the case that we took in the office. That they don't speak English, and they'll translate. That he have problem with the title, and he needed time. So
Okay.
only for you know that what they needed is a time.
Okay, how much
An
time he need?
extension.
Like 60, 90?
The most 90.
90? Okay.
Remember, this is the one I talked to.
Yes, the one with the, okay.
We wanna call that, okay. Is that?
Yeah, he's next.
Okay, perfect.
Yeah, formal.
Who serves as the interpreter?
Who's gonna serve as interpreter? Fair.
No, who served as the interpreter? Do you guys have a dedicated person you use?
No, we don't. It was sporadic at the moment, but they, Mary and Nestle said that they don't feel comfortable doing it. We have one more in the list. We have one more in the list.
Someone
Okay.
showed up.
Yes. You can. What is your list?
My list is.
Here's my,
I can write it.
4475.
4475.
Nancy Romero.
Nancy Romero. Thank you.
Pembroke Park Warehouse. Okay. Oh, they just arrived.
Everybody ready? Yes, we're ready.
Thank you, Ms. McKinney. May I call the next case?
Yes, please.
Sure, it is 10.2 on the docket, case 5552, Maria G. Ortega, 3100 Hallandale Beach Boulevard, lot 203.
Present.
Okay, you can present the case, Mr.
Cool.
Guston.
Code Officer Gene Guston for the Town of Pembroke Park, case number 5552, property owner Maria G. Ortega, site address 3100 West Hallandale Beach Boulevard, lot number 203, Pembroke Park, Florida. The notice of violation was sent by regular mail on March 2nd, 2021. A notice of formal hearing was sent by certified mail with a copy of notice of violation on July 20th, 2023, and posted on the property on August 2nd, 23, and Town Hall on August 4th, 23. The violations for work without permit: item 1, concrete slab installed without a permit; item 2, screen room addition installed without a permit; item 3, electrical and shed and screen room done without a permit; item 4, stairs at shed and RV installed without a permit. At current time, as of June 23rd, 2023, there was an affidavit of non-compliance. My recommendation is to give 90 days to comply or a daily fine amount of $100 per day after, with a $100 admin fee.
Hello, can you please state your name on the record and your position?
Oh, no entiendo. Mi nombre. Enay Boan.
Okay, so the code officer, and sir, I'm sorry, do you mind, because he,
If I may, Ms. McKinney, we need to find out the relation to Maria G. Ortega because she is the property owner.
Es mi cuñada.
And can we get the person's name who's translating for the record?
Juan Marquez.
Okay.
His relationship is his sister-in-law with Maria Ortega.
Can you just speak into the mic for the record, please?
His relationship to Maria Ortega is his sister-in-law.
okay, and Ms. Ortega has authorized you to speak on her behalf?
Que ella te autoriza para hablar sobre el caso.
Oh, no, ella no se encuentra aquí ahora.
She's not here.
Right, we realize that he's here, but my question is,
Autorización de ella para hablar sobre el caso.
is he authorized to speak on her behalf?
No tengo autorización de ella, pero es que yo le compré el trailer a ella. Y entonces ahora
He doesn't have authorization, but he bought the trailer from her.
Is that reflected in the file?
He's the owner.
I think she's still listed.
I spoke with this gentleman yesterday, and he mentioned that he is in the transition of changing the title to his name. Is that true?
Que tienes que cambiar el título, sigue el nombre de ella. ¿No lo has hecho o ya lo hiciste?
Oh, no, es que, mira, por falta del título, es que no puedo hacer los permisos que tengo que hacer para el trailer. Entonces, ellos me...
Because he doesn't have title, he's not able to fix the permits. So he's been trying to get the title under his name so he can get the permits.
Ellos me recomendaron que contratara un contratista que me pueda hacer esos permisos. Entonces no haría falta su permiso, el permiso de ella, en este caso.
Right, so he's trying to get with the contractor to do the permits, but until it's under his name with the title work, he can't do it because he would require permission from her, and she's not the owner.
All right. So my understanding with my conversation with him yesterday was that that he's having title issues of the property, but he is residing there, and he is going to make the efforts to correct the violations that he was unaware of. That he asked for the town to give him 90 days. Officer Gustin, can you repeat how many days? Did you present the case already?
Yes, I presented the case and then I recommended 90 days.
Okay.
The city doesn't, town doesn't impose.
Town attorney, what's the town's position with regards to, he's indicated that he doesn't have title, he's not Mrs. Ortega, but he's represented that he's purchased. I'm not sure if he's advanced a purchase and sales agreement to confirm the consummation of this exchange of property. What's the town's position?
Ms. McKinney, if I may, I think we should note the file that if the town's asking for 90 days, I would suggest that we continue this case either 30 or 60 days. Again, that should be considered in the 90 when the hearing comes back up. This then, Mr. Gustin can then get the information from this gentleman, make sure that, understand he's aware of the case right now, but the notice is issued to him as the owner, and that he's able to correct any title issues between now and then. And then in that case, in 30 days, bring the case back, and then we can have the case transferred to his name and notice provided to him as the owner.
Okay. So we're going to recalendar this for 30 days, but the sum total time for the violation to be corrected is 90?
Well, I think the special magistrate hearing the case should take that under consideration. So this is for the respondent that he should be taking efforts to correct these violations between now and the next hearing. I have a strong belief that the town's recommendation would be for 60 days if we come back in 30 days. At that point, we can then issue notice to him, or the title issues will be resolved. Either way, he still needs to get the title issues resolved in order to even get permits. Also, at that time, he can come back with somebody that can assist him in this hearing and provide translation.
And not to be a Debbie Downer, but worst case scenarios, if the title issue isn't resolved, because the town can check on property appraiser to see whether or not that has resumed. My concern is the fact that Ms. Ortega is not here with regards to, so.
Correct.
Do you want to just make it a 30-day continuance? And then pursuant to what the town attorney said, by that time, the title ought to be resolved and or compliance begun, and whoever is reflected as the owner can then get 60 days if the formal hearing ensues at that time. And then he can have an interpreter if he does in fact have title.
Correct. And then we can also make sure get his information and issue notice to him. And if we have proof that he's the real owner, then we can actually proceed forward in that case.
The only proof we can obtain to see if he's the actual owner is to see it on the title, and currently there is none. Officer Augustin, how did you get the name Maria Ortega for this property?
From the park manager.
Okay. So the mobile home park manager provides the owner's name. That's who they have registered as the mobile home owner. We cannot obtain this information on Broward County Property Appraiser. And again, I want to say that this violation has been open since March 2021.
Correct.
And there has been no efforts made to correct any of the violation, Officer Augustin?
They have made some efforts.
Okay, so they have complied how many out of the,
I would say about 2. I believe they removed the gazebo, and also it was a canopy.
so 2 out of the 6 violations?
Yes.
And Ms. Ramirez, if I may, and Town Attorney, Mr. Gustin has testified that notice has been properly provided to the owner. So that is not an issue. So if the town wishes to proceed in her absence, she is the registered owner. And thank you, Ms. Johnson, for edifying me as to how the owner information is confirmed. If the town is so inclined to proceed with the hearing, that is the town's prerogative, because due process has been accorded with regards to notice.
Then at that point, the case would proceed against
The registered owner, which
the
is
registered owner, unless the respondent has any additional information. Again, it's the testimony he's presenting is that he purchased it. I don't know if he actually completed that purchase or has any evidence. And again, you can always weigh the credibility of such testimony.
and I've already asked the town whether they've seen a purchase and sales agreement, which confirms the testimony that he's provided. Having seen none, this violation notwithstanding, when he purchased this, based on the record and testimony, stems back to March 1st of 2021, approximately 2+ years. So, and we're finally here at a final hearing. So this has been an ongoing, and that's why I proposed to the town, if the town would like to proceed as noticed for today's hearing, the town is free to proceed.
I would also like to add more information about the matter of the title. The person that sold this property to him is in Canada. So he is having a difficult time reaching out to the person to complete the transfer. So we don't know if that's going to happen in the 90 days. I would encourage to give the 90 days so pressure is put to make the transition of the title, and if not, he can require extension of time. But I feel like the violations have been neglected for quite some time, and I think it is the town's obligation to make sure that those violations are corrected.
If the gentleman is a prospective purchaser and the purchase is not yet completed, then at that point, we would proceed against the owner.
My position, based on the totality of the circumstance and the testimony provided, is to render an oral pronouncement with a per diem fine recommended by Mr. Gustin of $100 in 90 days as against the property owner, and then the parties can then resolve it amongst themselves. I'm going to provide the oral pronouncement, and then he can translate. Based on the testimony and evidence presented, there is substantial and competent evidence to support the city's position. The property owner, Maria Ortega, is hereby ordered to come into compliance within 90 days or face a $100 per diem fine, administrative cost in the amount of $100. Okay. If he could stand to your left, and then he can obtain an order. We can call the next case.
Case number 7.1, case 8439-5525 Southwest 41st Street, Pembroke, LLC. Case the address is 5525 Southwest 41st Street. 7.1 of the docket.
Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8439, property owner 5525 Southwest 41st Street, Pembroke, LLC. Site address 5525 Southwest 41st Street, Pembroke Park, Florida. A notice of violation was sent by regular mail, May 2nd, 2023. Affidavit of noncompliance and a notice of formal hearing was sent by certified mail, July 21, 23rd, posted to the property and town hall, August 4, 23rd. The violations are for item number 1, plumbing work done without a permit. Plumbing is illegally draining onto neighboring property located on 3707 Southwest 56th Avenue. Obtain plans for an after-the-fact permit and complete all inspections. Item number 2, portable container on premise without building official approval of permit. Obtain plans for an after-the-fact permit and complete all inspection. As of July 19, 2023, they did comply with item number 2. They did remove the portable container. However, they have not obtained permits for the illegal plumbing work. It is my recommendation to give them 60 days, if not a $250 per diem and $100 admin fee.
Good morning. Can you please state your name and your position as to the violation?
Good morning. My name is Roberto Gonzalez. I'm property manager at the Iller on 41st. Used to be known as Crosswinds, 5525 Southwest 41st Street. I would love to have a little bit more time with this violation when it comes to the plumbing work that we performed there. This is regarding flooding issues with our tenants living on the first floor. We have Section 8 tenants, disability tenants living on the first floor apartments. 113 apartment, 117 that's located in the backside of the property. We actually have sandbags over there because of the floodings that we have been facing ever since we took over the property 6 months ago. This is something that the previous owner was supposed to fix, but was never completed before. So now we are coming up with a plan. We did have an engineer 2 weeks ago to calculate water distribution across the building, because it's definitely not an easy fix. It involves architects, engineers, and we actually did we installed a waterproof roof job, but it definitely did not fix the issue because it's retaining a lot of water. But now we tried this easy fix. We tried to call it a day, but they definitely did not do a good job because it was not supposed to go to the backside of the property. And we definitely sealed it, so there's no water coming back. Now we sealed the whole piping that was created coming directly from the back of the property. So I would love more time to fix this issue. We are already on it. We just need the certain plans, how much it's going to take. And I obviously don't have a clear date, but we do need more time.
So the issue is that the building official mentioned that you cannot drain these, whatever is coming out of those drains onto someone else's property. Drains have to be properly connected to an appropriate location for drainage. The fact that it was done to someone else's property and it's being drained, it is also a violation of Broward County's code. So I understand that there's an emergency, but on base of emergency, contractors have the obligation to identify what's the emergency of that work and get permission from the building official to do that type of work. But the way it was done is poorly done, and it cannot be drained onto somebody else's property. This has to be corrected right away. I think this town has given enough time to do that since May, and we're here in August. It needs to be corrected. 60 days, I think it's more than enough time to do it. It should not be on someone else's property.
Anything else, Mr. Gonzalez, before I give a pronouncement?
So we did seal the pipes. Now we are just looking to get an after the fact permit. Is that what we're asking for?
You seal the pipes?
We sealed the pipes. There's no water coming out. The water that was coming out of there is just rain, basically. It was regular water.
Okay, but again, if you continue repairing and doing work, you're still doing it without a permit. There hasn't been a permit in the system for all this work that's been done.
Well, if it came to my mind that if we did not seal the pipes, we would definitely have, we would certainly would have a bigger issue with the water, because it was a lot of water coming out of that pipe. So, you know, we had to seal it. Eventually, there was way too much water. The property was built in 1976, and it retains basically all the water because of the paver system that we have inside the courtyard right next to the pool area. So we couldn't do anything about it other than just seal it. And now, given the chance, apply for an after-the-fact permit and get it done as soon as possible.
So is it still draining on someone else's property?
No, not at all.
Okay, so I will have to re-inspect that?
Yeah.
And again, if you need more than 60 days, you can come back for an extension. But we need to see the effort made in 60 days.
Sure thing.
Yeah.
Okay. Based on the testimony and evidence presented, there is substantial and competent evidence to support the city's position. You are hereby ordered to comply or bring the property into compliance within 60 days or face a $250 per diem fine. You will also be assessed $100 for this hearing for the administrative costs. Good luck to you.
Thank you.
We can call the next case.
Case 11.2 under docket, case 6743, Prologis Exchange, Pembroke Road, and 30th Avenue LLC, located at 3898 Pembroke Road.
Good morning again.
Good morning.
Code Officer Gene Gusson for the Town of Pembroke Park, case number 6743, property owner Prologis Exchange, Pembroke Road and 30th Ave LLC, site address 3898 Pembroke Road, Pembroke Park, Florida. The notice of violation was sent by regular mail on February 22nd, 2022. A notice of hearing to confirm fine was sent by certified mail with a copy of notice of violation on July 20th, 2023, and posted to the property on August 2nd, 2023, and Town Hall on August 4th, 2023. The violations for item 1, operating without a business tax receipt, BTR, and item 2, commercial racking system installed without a permit. At this current time, as of July 19, 2023, there was an affidavit of non-compliance. The property is still not in compliance, so it is the town motion to confirm the fine amount of $67,350.
Good morning. State your name for the record and who you are in relation to Prologis Exchange, Pembroke Road, and 30th Avenue LLC.
Yes, good morning. My name is Juan Carlos Marquez. I am the general manager for Zyno Inc., which is the lessor for Prologis Exchange in the said address. And Ms. Liliana Ramirez is the president and owner of Zyno Inc., the lessor of Prologis Exchange for 3898 Pembroke Road.
Okay, so the code officer has testified that the property remains still not in compliance, and the town is seeking to confirm a fine amount of $67,350.
Yes, and to this, well, first we would like to explain the situation, if at all possible. Basically, we hired someone to perform some work. First, it was the racks, and then they also performed additional work into some office cubicle work inside the premises, and then we also tried to get our business tax receipt and the permit for the racks during this time, but because we are not up to code on any of those things, and the contractor that we had hired had since basically abandoned us and the project, we have tried to get other contractor, which through calling through multiple architectural firms, working directly with Prologis' people to try to get someone to help us to get up to code during this time. And yet nobody wants to touch someone else's work is what we've been giving. So we're kind of at what do we do now? And we've continued to try to look for other options into getting a contractor that will take on the case and will help us fix these issues. And usually what we are being given are solutions that are extremely out of proportion. And I mean, first of all, we're relatively new to Pembroke Park Town. And when we moved here from Aventura, we wanted to install racking so that we can do business, right? Without this, basically, there's no point for us to be here at all. Is to be able to keep our business moving, and we have done every effort into trying to get to compliance, and then not to say that it's not our fault to have a contractor abandon us. We've been trying to find a new contractor to take over to do this matter, and unfortunately we have no one at this time to come with us and basically do the work. We've been referred to other people, but it's like the chicken or the egg. What comes first? Like, can we get the permits and get everything ready? And I believe, to my personal knowledge, is that the work is up to code. It's just it hasn't been verified by Prologis and well, I mean, by the city to be done so, and so we can get the permits and get everything ready. So the issue for us remain is that we're requesting some more time so we can finally have someone come to us and help us be, finishing the permits and get the work accomplished so that we can move on.
Thank you, Mr. Marcus, for your testimony. I'm looking at the file, and it's unfortunate that you had a contractor abandoned. Have you not reached out? Do you have a contractor in mind?
We do, and even actually the attorneys from Prologis, who is a much larger corporation than us, we're just very small fish. Prologis is $1 billion corporation, and they've threatened and tried to pursue this contractor that did the work that is currently there, and there's no luck. So we've kind of shifted, instead of trying to go against that contractor and that company and that person's license or whoever. Apparently they moved out of state and they're no longer in Florida. It's what we've learned. We're trying to find someone new, and in these attempts we've reached out to multiple firms, at least half a dozen firms, and most of the responses are we can't touch somebody else's work, or we would need to basically redo the entirety of the work, basically take it all off and put it all again.
Many things.
And the ones that don't say that are quoting us hundreds of thousands of dollars, which, I mean, honestly, we simply do not have. I mean, again, we're a small fish, and this is not even our property. Yes, we're responsible for the work performed, but the things that we did were in basic nature for us to continue doing business, and we want to do business in the town of Pembroke Park. It's a very nice town. The building is very nice, and we've tried to do everything in our power to do so, investing literally a lot of resources and money that basically we don't even have. We've invested more than $150,000 of our own funds from the company into trying to get this resolved. And Prologis has not even given us not $1 back, meaning the landlord has not credited us back. They have not provided any assistance or in any way. They've kind of given us some guidance into what to do, which is find another contractor. Here, try this one. And we try with that one, and it's a dead end. So at this point, we're here, and we want to show that we do want to get to compliance. We do want to do everything by the book, and hopefully maybe the town can refer us to somebody and allow us some more time for us to complete this matter and get it resolved. It is in our best intention. That's why we're here, to get this resolved and we can continue doing business as usual. We
No.
signed a 10-year lease, for Christ's sakes. I mean, we want to be here for the long term.
And do the best from our side.
No, I completely understand. A review of the file indicates that this has been ongoing quite some time, and you've already testified with regards to the contractor. And so today the fine has accrued to over $67,000. And it sounds like part of the issue is that Prologis was trying to recoup their losses or the losses from the prior contractor, but some of the energy really ought to have been expended in procuring another contractor. And it is unfortunate that another professional may not want to undertake the work commenced by another professional because they kind of endorse that. And it's not uncommon where a new professional is going to want to draw up new plans. And that's part of the cost of really doing business and being a lessor, an owner, etc. And so with that being said, while I'm sympathetic extremely to your situation, because unfortunately these things do occur more often than they probably should, but it still leaves you in the same position with the violation that was issued back in February. And it doesn't sound like, and I'm not saying this is through no fault of your own, but things that have happened, that you're not any closer to being able to like touch down, if I may, as to coming into compliance. So with that said, my oral pronouncement is that I will be confirming the fine amount in the amount of $67,350 based on the testimony evidence presented. I do find there is substantial and competent evidence to support the confirmation of the fine. The fine will continue to accrue, right? And so with that being said, you are strongly urged to do your hardest in working with also with Prologis and finding another contractor. Otherwise, this amount will continue to grow. Everything that you've set forth here today, definitely you can, once the property is in compliance, come back to the town and request an abatement, setting forth all the grounds that you have indicated here today. So,
Yeah, I mean, but we would have to do so at when the process is completed, correct? Like
everyone, abatement comes at the end for everyone when the process, and by process, when the property...
permits are closed.
Yes. Yes. And so with today's order, that may be something that you may want to share with Prologis and getting them to greater assist than what they've already done.
Okay.
Okay. Good luck to you guys.
Thank you.
Ms. McKinney, the next case is case number 8.1, case 4475, Pembroke Park Warehouses Holdings, case 3140 Southwest 19th Street, Bay 685.
Chief Code Officer Joseline Ramirez for the Town of Pembroke Park, case 4475. Property owner Pembroke Park Warehouse Holdings, site address 3140 Southwest 19th Street, Bay 658. A notice of formal hearing to abate fine was sent by certified mail July 21, 23rd, posted to the property and town hall August 4, 23rd. It is the town's motion to abate the fine of $61,607 and reduce it by 85%. That includes the recording lien fee of $48.50, the release of lien $8.50, and the $100 administration fee. The total is $9,375.
Good morning. If you can please state your name and your position as to the abated amount that the town has recommended.
Good morning. My name is Nancy Romero. I'm the general manager for the ownership.
Hello, Ms. Romero.
Can you repeat again the fines?
Yeah, the total amount of the fine accrued is $61,607. And then the reduction is 85%, including all administration fee, is $9,375.
And this goes back like
2019.
Okay. nothing to say.
Okay. Hearing no statement or testimony from the respondent, based on the testimony and evidence presented, there is substantial and competent evidence to support the city's abatement position, reducing the total fine from $61,500 to $9,375. This does also include a $100 administrative cost assessed for today's hearing. The total amount of the reduced fine amount must be paid within 30 days, or the original amount will revert back.
Okay, thank you.
Good luck to you.
Ms. McKinney, that completes your in-person docket. We'll continue through the docket. There are no respondents here for the remaining cases. The next case is 8.5, case 6313, Holly Ridge Apartments LLC, care of Elon Property Management, 3125 Southwest 52nd Avenue. Yeah. And that was the next one in order anyway. The first one there.
All right.
This is the one with
The one that was
the wit.
agreed. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 6313. Property owner Holly Ridge Apartments LLC, care of Elon Property Management. Site address 3215 Southwest 52nd Avenue, Pembroke Park, Florida, Unit 84. This hearing to abate fine was requested via email August 11, 2023. It is the town's motion to abate the fine of $91,407 and reduce it by 80%. That includes all administration fees. The total is $18,407.
That was $18,407.
Mm-hmm.
Yes, Mr. Kinney, and for the record, Attorney Richard DeWitt for the respondent was in communication with the town and has agreed to the fine, with the reduction of fine.
Okay, thank you for that. Based on the testimony and evidence presented, there is substantial and competent evidence to support the city's position for an abatement of fine. And this is for case number 4933 in the amount of $18,407. This includes an administrative cost of $100. This correction, 6133.
6313.
Oh, I'm sorry. I misheard. The case number for the record is 6313, again, by the agreement of the parties and the testimony and evidence presented by the code officer. The abated amount is $18,407. That includes a $100 administrative cost for this hearing. The respondent has 30 days to pay the full amount. Otherwise, the amount will revert to the original amount of the fine.
Next case is case number 9.1 on the docket, case 7225. This is a request to extend time. Murray Family Associates LLP, 3192 West Hallandale Beach Boulevard, Unit B.
Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7225. Property owner Murray Family Associates LLP, site address 3192 West Hallandale Beach Boulevard, Unit B, Pembroke Park, Florida. A notice of hearing to extend time was requested on August 11. Person. It is the town's motion to extend the time by 30 days, and everything else remains the same. Let me get you those fees. It's $100 per day and a $100 admin fee.
Case number 7225, let the record reflect there is no one present here on this case. Based on the testimony and evidence presented by the code inspector, there is substantial and competent evidence to support the extension of 30 days to come into compliance, or a $100 per diem continued fine will continue to accrue. There is $100 assessed for today's hearing. Next case.
Case is 10.1, case 5053. The remaining cases all first-time hearings. Pembroke Road Center LLC, 3932 Pembroke Road, Pembroke Park, Florida.
Code Officer Gene Gusson for the Town of Pembroke Park, case number 5053, property owner Pembroke Park, Pembroke Road Center LLC, site address 3932 Pembroke Road, Pembroke Park, Florida. The notice of violation was sent by regular mail on April 16, 2020. A notice of formal hearing was sent by certified mail with a copy of notice of violation on July 20th, 2023, and posted on the property on August 2nd, 2023, and Town Hall on August 4th, 2023. The violation is for item 1 for illuminated wall signs will install without a permit, and at this current time, as of June 22nd, 2023, there was an affidavit of non-compliance. My recommendation is to give 30 days to comply or a daily fine amount of $250 per day after with a $100 admin fee.
Case number 5053, seeing no one come forward. Based on the testimony evidence presented, I find that there is substantial and competent evidence to support the city's position. The respondent is hereby ordered to come into compliance within 30 days or face a per diem fine. Again, Mr. Guston, that fine amount is?
The fine amount will be $250 per day.
Or the respondent shall incur a $250 fine, daily fine. $100 admin costs are also assessed for today's hearing. Next case.
Case 5464 against Yvonne Cole, 5417 Southwest 41st Street, Pembroke Park, Florida.
Code Officer Gene Gusson for the Town of Pembroke Park, case number 5654, property owner Yvonne Cole, site address 5417 Southwest 41st Street, Pembroke Park, Florida. The notice of violation was sent by regular mail on March 22nd, 2021. A notice of formal hearing was sent by certified mail with a copy of notice of violation on July 20th, 2023, and posted to the property on August 2nd, 2023, and Town Hall on August 4th, 2023. The violations for item 1, AC installed without a permit. At this current time, as of July 12, 2023, there was an affidavit of non-compliance. My recommendation is to give 60 days to comply or a daily fine amount of $100 per day after with an admin fee of $100.
Case number 5654, seeing no one come forward. Based on the testimony and evidence presented, there is substantial and competent evidence to support the city's position. The respondent is hereby ordered to come into compliance within 60 days or face a daily per diem fine of $100. $100 administrative costs are assessed for today's hearing. Next case.
Case 6121 against Victor Jimenez, 3140 West Hallandale Beach Boulevard, lot 526.
Code Officer Gene Gusson with the Town of Pembroke Park, case number 612 Jimenez, site address 3140 West Hallandale Beach Boulevard, lot 526, Pembroke Park, Florida. The notice of violation was handed on August 4th, 2021. A notice of formal hearing was sent by certified mail with a copy of notice of violation on July 20th, 23, and posted to the property on August 2nd, 2023, and Town Hall on August 4th, 2023. The violations for work without permit: item 1, concrete walkway built without a permit; item 2, concrete pavers built without a permit. At this current time, as of June 23rd, 23, there was an affidavit of non-compliance. My recommendation is to give 30 days to comply or a daily fine amount of $100 per day after with a $100 admin fee.
Case number 6121, seeing no one come forward. Based on the testimony and evidence presented today, there is substantial and competent evidence to support the city's position. The respondent is hereby ordered to come into compliance within 30 days or face a $100 per diem daily fine. $100 administrative costs are assessed for today's hearing.
That's another one.
Next one is case 6522, 10.6 on the docket. Christian Chevalier, 142 Lake Drive, Pembroke Park, Florida.
Code Officer Gene Guston for the Town of Pembroke Park, case number 6522, property owner Christian Javier, site address 142 West Lake Drive, Pembroke Park, Florida. The notice of violation was sent by regular mail on November 16, 2021. A notice of formal hearing with a copy of notice of violation was sent by certified mail with a copy of notice of violation on July 20th, 2023, and posted to the property on August 2nd, 2023, and Town Hall on August 4th, 2023. The violations for work without permits: item 1, gazebo installed without a permit; item 2, camera system installed without a permit; item 3, windows installed without a permit; item 4, stair rails installed without a permit; item 5, shutters installed without a permit; item 6, sliding glass doors installed without a permit; And item 7, fence installed without a permit. At this current time, as of July 20th, 23, there was an affidavit of non-compliance. My recommendation is to give 60 days to comply or a daily fine amount of $100 per day after with an admin fee of $100.
Case number 6522, seeing no one come forward, based on the testimony and the evidence presented, there is substantial and competent evidence to support the town's position. The respondent is hereby ordered to come into compliance within 60 days. And Mr. Gusson, that was a $100 per diem fine?
Correct.
Or face a $100 per diem fine and $100 administrative cost for today's hearing. Next case.
The next case is 8625 Daniel Sanchez, 2304 Southwest 31st Ave, Pembroke Park, Florida.
Code Officer Gene Guston for the town of Pembroke Park, case number 8625, property owner Daniel Sanchez, site address 2304 Southwest 31st Avenue, Pembroke Park, Florida. The notice of violation was handed on June 16, 2023, and sent by regular mail on June 21st, 2023. A notice of formal hearing with the copy of notice of violation was sent by certified mail on July 24th, 2023, and posted to the property on August 2nd, 2023, and Town Hall on August 4th, 2023. The violations for item 1, fence installed without a permit. Item 2, overgrown landscape throughout premises. At this current time, as of July 12, 2023, there was an affidavit of noncompliance. My recommendation is to give 60 days to comply or a daily fine amount of $100 per day after, with a $100 admin fee.
Didn't we hear this? Case number 8625, seeing no one come forward. Based on the testimony and evidence presented, I find that there is substantial and competent evidence to support the city's position. The respondent is hereby ordered to come into compliance. And again, I'm sorry,
60 days.
60 days or face a per diem of $100 and $100 admin cost.
Next case is case 8535 Lacey Top, 2306 Southwest 31st Ave, Pembroke Park, Florida.
Code Officer Gene Gusson for the town of Pembroke Park, case number 8535, property owner Leslie Tape, site address 2306 Southwest 31st Avenue, Pembroke Park, Florida. The notice of violation was sent by regular mail on May 23rd, 23. A notice of formal hearing was sent by certified mail on July 20th, 2023, and posted on the property on August 2nd, 2023, and Town Hall on August 4th, 2023. The violations for work without permit. Item 1, screen enclosure installation without permit. Item 2, barred doors installed without a permit. Item 3, wooden and vinyl fence installed without a permit. Item 4, concrete slab pavers built without permit. At this current time, as of July 19, 2023, there was an affidavit of noncompliance. My recommendation is to give 60 days to comply or a daily fine amount of $100 per day after with a $100 admin fee.
Case number 8535, seeing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position. The respondent is ordered to come into compliance within 60 days or face a $100 per diem fine. $100 for administrative costs are assessed for today's hearing.
Okay.
Is that the last case?
Yes.
That's it.
Okay, we stand adjourned.
At 11:14 a.m.